Hello, and welcome to this webinar on patent basics. This is the third webinar in our NYSBDC Business Learning Lab Fall 23 featured series on intellectual property in partnership with the U.S. Patent and Trademark Office. I'm your moderator, Jenny Alton from the New York Small Business Development Center Central Office. Today, we have with us Monica Shin and Anna Murasan, who are primary patent examiners and assistant outreach coordinators for the Eastern Regional Outreach Office of the USPTO. Monica will present today, and Anna will answer questions behind the scenes. This webinar is brought to you by the New York Small Business Development Center network of 20 campus-based centers and outreach offices, which are located across New York State, along with the central office based in Albany. The NYSBDC is a U.S. Small Business Administration resource partner. Our free advising, education, research, and advocacy services are made possible by funding from the SBA, New York State, and our host campuses. So you know, this session is being recorded. We will share it with attendees in the next few days, along with a PDF copy of the slides through a follow-up email. Attendees are muted and will not be on camera today. Your chats will only be visible to me and our wonderful people from the USPTO. If you have any questions during the presentation, please don't hesitate to type them in the Q&A box as they come up. You can open Zoom's Q&A box from the Q&A button at the bottom of your Zoom window. Like I mentioned before, Anna will be answering questions as we go. But for very specific questions that may take more time and detail to answer, or if we run out of time to answer all questions, you will be able to get in touch with them through the contact information they will share during this presentation. You can also reply to the follow-up email you will receive to get further assistance. And with that, I will turn the time over to Monica.
Great. Thank you, Jenny, for that great introduction. So today we're going to be talking about patent basics. Before we begin, please note that this content is for informational purposes only and is not legal advice. So please consult with the appropriate sources for legal authority and guidance on these matters. So the objectives for today's presentation is to go over the contents of a utility patent application disclosure, learn about the enablement requirement, understand that the limitations of claims can be modified based only on what was disclosed at the time of filing, and the importance of capturing your invention using clear and consistent language throughout the disclosure. So there are two types of applications you can file for utility applications, a provisional and a non-provisional application. So you have the option of first filing a provisional application, which establishes a filing date for your invention. And this is important because the US is a first to file system. In a provisional application, there are no claims are required, and a provisional application is not published and it will not be examined. So a provisional application itself will never result in a patent. A provisional application is valid for 1 year, so it essentially gives you 1 year to decide whether or not you want to pursue a non-provisional application on your invention. So you can think of a provisional application as a kind of a save the date for your invention. In this 1 year that the provisional application is valid, you can do, for example, market research to see whether you want to continue to pursue a patent on your invention. You can work on drafting up claims, etc. Now, a non-provisional application is what actually gets examined by a patent examiner like Anna and myself. And a non-provisional application can result in a patent. Non-provisional applications get published 18 months from the earliest filing date, and there are statutory requirements that must be fulfilled for what gets filed. Now, it's important to note that in order for your non-provisional application to get the full benefit of the provisional application's earlier filing date, the provisional must fully support whatever subject matter that you claim or disclose in your non-provisional application. And with regards to the patent term, the patent term is measured from the filing date of the non-provisional application. So the specification is a part of the application and should provide a written description of the invention. The specification describes how to make and use your invention. It should be set forth in clear, full, concise, and exact terms to allow a person skilled in the art or the technology of the invention to make and use the invention. The specification should include at least one specific embodiment, and it concludes with at least one claim, which must begin on a new page. Now, this slide lays out the formatting of the specification, which are discussed in MPEP section 608.01. The specification, including the abstract and the claims, must have lines that are 1.5 or double spaced in a single column of text. It must be written on only one side in portrait orientation. The page must be 8.5 by 11 inches with margins of at least 3/4 inches, except for the left side margin, which must be at least 1 inch. Now, the application must be numbered consecutively starting with page 1, and the page numbers must be centrally located above or below the text. And the specification must also be written in non-script font, preferably with a font size of 12. So now let's look at the sections of the specification. The specification includes the title of the invention, which should be short and specific. And then some of the more common applicable sections include a background, which discusses the state of the art before your invention, a brief summary of your invention, a brief description of the drawings, which is a listing of all the figures by number with a brief statement of what each figure depicts, and a detailed description of the invention. And then on a separate sheet, you must also have at least one claim. And on another separate sheet, you must have an abstract, which is one paragraph, less than 150 words. And the MPEP section 608.01a discusses the arrangement of the application and lays out the order of the specification, sections of the specification. Now, these are some of the less commonly used sections of the specification, and they're only applicable in certain applications. So I do want to point out that a cross-reference to the related applications should be included if you are filing a continuation, divisional, or claiming priority to a provisional application. So in the next several slides, I'll be referring to specific sections of the MPEP, which I believe I've already also referenced. The MPEP is the Manual of Patent Examination Procedure, and it sets forth all the laws and regulations that must be followed during examination of patent applications. And the full text of the MPEP can be found on the USPTO's website. So now we're going to go a little more into detail about the required and more common sections of the specification. Now, the title of the invention should be short and specific and be descriptive of your invention. You should think of the title as a quick description of your invention, and it should allow a reader to readily ascertain what your invention is. So you should try and avoid generic language such as system and method for. Now, the background of the invention section would be where you can describe at a high level the areas or fields that are pertinent to your invention. You can also describe the prior art related to your invention, such as what you know have been done before, problems that led you to come up with your invention, and descriptions of prior art that you know about. Now, the brief summary of the invention section is where you would provide a high-level description of your invention and what it does. You can describe the problems that you solve using your invention and describe what makes your invention unique or different. Now, if you submit drawings with your application, your specification must include a brief description of the drawing section. If you have drawings, the section must be provided before your application is considered complete and released from initial processing. Now, the brief description of the drawing section includes a listing of all the submitted figures and a brief statement about what each figure depicts. The drawings are a required part of the disclosure of your invention if they are required to understand the invention. Now, all drawings necessary to understand the invention must be submitted with the initial filing of your application, as they will not be allowed to be introduced after the filing date. The drawings must show every feature of the claimed invention, and they must contain as many views as necessary to show your invention and understand your invention. Now, 37 CFR 1.84 sets forth the standards for drawings. Generally, black and white drawings are normally required for utility and design applications, and color drawings are permitted in design applications. Color drawings may be accepted in utility applications, but only after the granting of a petition explaining why the color drawings are necessary. And more details about drawing requirements can be found on NPEP section 608.02. Now, these are the requirements for drawings. And again, drawings are only required if they are necessary to understand the invention. Black and white drawings are normally required, and the lines and numbers must be heavy enough to permit adequate reproduction. Each figure must be labeled, for example, with figure 1, figure 2, figure 3, etc. And reference characters should be used to denote specific components of the figures. Now, each reference character should be used consistently, with no single character being used for more than two different parts, for use for more than one different part. And each reference character used in the drawings must be described in the description, specifically in the detailed description of the invention section, which we'll go over in a few slides from now. And you should avoid using descriptive words in the figures. And again, more details of the drawing requirements can be found on NPEP section 608.02. Now, the abstract must start on a separate sheet with the heading Abstract. The abstract is a single paragraph in narrative form, and it must be 150 words or less, and 1.5 or double spaced. The abstract should not be a repeat of the claims or a brief summary section, but rather the abstract should point out what is new in the technology, and it's written to enable the public to quickly determine the nature of the technical disclosure of the invention. NPEP section 608.01b discusses the requirements for the abstract. So the detailed description of the invention section of the specification should provide clear support or antecedent basis for all terms used in the claims, so that the meaning of the claim terms in the claim may be ascertainable by reference to the description. So now this is more of an opinion or suggestion, but it can be helpful to draft your claims first. So going back to the fence analogy that I used earlier, where your claims are the fence and your specification is your bag of materials to build the fence, it may be easier to determine what materials you need to build your fence once you have a visual of what you want your fence to look like. So by drafting the claims first, you can decide on the terminology to use, and the terminology you use must be consistent throughout the specification. You can also figure out what terms need to be defined or explained in more detail in the specification. The claims can serve as a checklist to make sure that the detailed description provides support for the claims. You also want to keep in mind what direction that you may want your claims to go in throughout the examination process. So, for example, if you want to amend your claims to overcome prior art rejections by adding new limitations into the claims, those new limitations must have support in the specification. So, what that means is that those new limitations must come from somewhere in the specification as originally filed. Now, again, the claims to specification order is just a suggestion and a matter of personal preference. You may find that it may be more helpful for you to write your specification first, then derive your claims from that. But in all cases, this is an iterative process going back and forth between the claims and the specification to iron out all the differences and ensure support, consistency, and antecedent basis between the two sections. So now we're going to do a review of everything we've just talked about with regards to the specification component with some do's and don'ts. So things that you should do. You should describe the invention clearly so that any person skilled in the art, that is the invention's field, can make and use the invention without undue experimentation. If you have drawings in your specification, when referencing the drawings, be sure that each reference numeral is used for only one part depicted in the drawing and that it's used consistently, and that each reference numeral that's shown in the drawings is mentioned in the specification. You should also provide at least one specific embodiment, including the best one known to you at the time of filing. If you're submitting drawings with your application, you want to make sure that there is a brief description of the drawing section that includes each figure referenced by its full label. And also, if you're going to be using figure labels such as 1A, 1B, and 1C, they should each be individually mentioned and described and not collectively referred to as figure 1 in the brief description section. You also want to make sure that there is proper antecedent basis for all terms in the claims. And finally, you should focus on the technical features of your invention. Now, these are some things to watch out for when you're writing your specification. You should not use trademarks in the title or to describe structure, or use a mark you intend to register for a commercialized product. So, for example, you should not use Velcro to describe a hook and loop fastener, but rather you should actually explicitly describe a hook and loop fastener. The background of the invention section does not need to state how the inventor conceived the idea. So, for example, you don't need to include that you came up with this idea while jogging. You should avoid making claims of possible future success, for example, that this invention will sell and make millions, or that this invention will revolutionize the field. And you should not include and also do not include a detailed discussion of the figures or refer to the reference characters in the brief description of the drawing section. That should all go into the detailed description of the invention section. And also do not forget to proofread your specification and look for grammatical and typographical errors. For some examples of specifications, you can do a patent search on your database of choice of patent applications in your inventions field to get an idea of like what terms or wordings are generally used and what types of features are talked about in the specification to help you get started. And so now we're going to move on to the claims. The claims define the invention and what aspects are legally enforceable. They encompass the boundaries of your invention. So a claim defines the invention, um, but but it must be supported by the specification. Now, what does this mean? It means that the terms and the phrases used in the claims must find clear support or antecedent basis in the description, so that the meanings of the terms in the claims are clearly understood by reference to the description. So, what are some specific details? You should start the claims on a separate sheet with a heading called claim listing, and the claim sentences should be 1.5 or double spaced. Each claim is a single sentence that begins with a capital letter and ends with a period, and you can use commas or semicolons in each claim sentence to clearly claim or describe your invention. But remember, each claim must only have a single period. Now, keep in mind that there are additional fees required if you have more than 3 independent claims or have more than 20 claims in total. You must number the claims consecutively in ascending order. So, for example, 1, 2, 3, 4, and so on. And the original numbering of the claim must be preserved throughout the prosecution. So, for example, if you originally file claims 1, 2, and 3, then decide to rewrite claims 1, 2, and 3 completely, what you can do is cancel claims 1, 2, and 3, then add claims 4, 5, and 6. But what you shouldn't do is to first cancel claims 1, 2, and 3, and then add again claims 1, 2, and 3 to the claims of your invention. So basically, once you cancel a claim, you cannot add that same claim number back again, but you can add a new claim number with essentially the same claim language as the canceled claim. So, what are some of the claim requirements? Now, again, a non provisional application must have at least one claim, and the claim must particularly point out and distinctly define the invention. the claims are written in independent or dependent form, and there must be at least one independent claim. A dependent claim necessarily incorporates by reference all of the limitations of the claim to which it refers to. So, in other words, a dependent claim incorporates all of the elements of the independent claim from which it depends. So, dependent claim must refer to to a preceding claim so that the reader knows what claim the dependent claim is depending from, and the dependent claim must further limit the claimed invention. So, in other words, a dependent claim is broader than an independent claim is broader than a dependent claim. So, as an example, an independent claim could be like a house, and a dependent claim could be the rooms in that house or the specific size of the house. The boundary of the dependent claim is more narrow than the boundary of the independent claim from which it depends. And we'll see a little more later on. So, how do you plan to write a claim that best reflects your invention? Now, drafting a claim is an art. So, not only do you need to claim something that reflects your invention, but also you want to protect your idea from being stolen by a workaround. Now, when a claim is too specific, it might not provide as much value because others can easily work around it. However, on the other hand, if your claim is too general, it might not be patentable because it's possible that your general claim might already be known in the field. So, what you want to think about finding is that balance between an invention that's too general and one that's too broad. Now, this would be an example of a claim that's too broad, for example. And now, why is this too broad? So, let's say you want to cover a claim that is directed to this yellow car. However, this claim is too broad because it could also cover a covered wagon. This covered wagon also has a frame, it has a first and second front wheel, etc. So everything that's in the claim is also found in that wagon. So it's a little too broad. So what could you do to add to the claim to make this a little more narrow to be more reflective of your actual invention, this yellow car on the left? Um, you can think about what differences there what are the important differences between, for example, these two items. Now, on the flip side, this may be a claim that may be too overly specific. So while the motor, for example, does distinguish from the yellow car from the covered wagon, but the second requirement, a yellow frame, does the frame have to be yellow? So that may be something that's a little too specific. That may be an easy workaround for others to get past your claim. So it's the important thing is to find that balance between being overly broad and overly specific. So when you draft a claim, you should think about what you are trying to invent. Is it a tangible thing or a product like a composition of matter or an apparatus like a machine or an equipment needed to do a particular for a particular purpose? Or is it a method of making a tangible product or using the tangible product in some way of or doing something? If you're claiming a tangible product, you should claim the components or pieces that compose the invention and how they're interrelated. You're allowed to claim multiple inventions. So, for example, one independent claim may be directed to a composition, and another independent claim may be directed to a method of using that composition or method of making that composition. You can also claim multiple versions of each invention. So, for example, one independent claim may be maybe a product A, for example, a car with two doors, and another independent claim can be directed to product B, which could be a car with four doors. So you should also think strategically when drafting your claims. Think about what goals you want to accomplish. Do you want to obtain the broadest valid claim? Or do you want to obtain claims with a variety of types and scope in one application filing? And keep in mind that your goals may change, and with that, your strategy may change throughout the prosecution. So maybe at the time of filing, you have a different goal, but during prosecution, after seeing the prior art or the office action from your examiner, you might want to adjust your goal or strategies because what you claim might not be patentable based on the prior art cited. So you might just have to adjust your fence and make it a little more narrow. Now, remember, it is possible, though, that some claims that are filed are likely to be patentable without amending. Uh, when thinking strategically about writing up your claims, something that you might want to consider is your budget and the fees that it costs to write certain claims. So, for example, you're allowed to file 3 independent claims without an additional fee, and any additional independent claim will be subjected to a fee. You're also allowed to file 20 claims without any additional fee, but anything more is subjected to a fee. And please note that the costs on this slide are for a micro entity status, and they are subjected to change. Subject to change. So please check the USPTO website for the most up-to-date fees. So in general, when drafting a claim should have 3 main parts: a preamble, or the introduction of what type of claims you are intended to claim. For example, a method, an apparatus, or a composition. So a preamble could be a method of making a car. Next, you'll need a transitional phrase such as comprising or consisting of, and we'll go into what this means in the next slide. And finally, the body of the claim that recites the elements of the invention. So, as an example, a method of treating headaches is a preamble, comprising is a transitional phrase, and administering ibuprofen to a person in need thereof would be a body reciting elements of your invention. So these are the transitional phrases comprising or consisting of. So, what are the difference between these two? Comprising is an open ended phrase and it does not exclude additional unrecited elements or method steps. So, for example, if you say for claim 1, a method of making a car comprising attaching a joystick to the frame and attaching the wheel to the frame, because because of the phrase comprising, the method of making a car could have other things that are added to the dependent claim. So, claim 2, that depends from claim 1, could further recite that the method of claim 1 further comprises attaching an engine to the frame. Now, consisting of is a closed language and it excludes any elements or steps or ingredients that are not specified in that claim. So, anything that with consisting of is limited to whatever you write in that claim. Now let's look at some do's and don'ts of claim drafting. So, what are some of the do's? Look at the claims in the patents issued in your field of technology as a guide, for example. One way to do this, and you can use the search engine of your choice to see what kind of claims are drafted in your technology field. When writing the claims, you should particularly point out and distinctly claim the subject matter regarded as your invention. Consider drafting your claims first and then your specification based on the terms used in the claims. Now, as I said earlier, this like claim to specification or specification to claim is a personal preference, and it'll just take some iterations to figure out which works best for you. You should review both the claims and the specification to make sure that necessary additions and corrections are all made so that the claim terms find support in the specification and ensure that each term has proper antecedent basis. And you should also think about what legal protections you need for your invention and tailor your claims accordingly. And you should repeat this process to refine your claims and specification. So maybe things that maybe you should avoid doing. when drafting claims. You should not write your claims that cover two statutory classes of invention. So you cannot combine a method and an apparatus in a single claim. It should be separated out. Do not use terms inconsistently between the claims and specification. So if you're using, for example, motorcycle in the specification, use just motorcycle for motorcycle. Do not start calling it, for example, a bike or a bicycle. You want to keep your language consistent. You should not write multi-sentence claims. Remember, each claim is just a single sentence, starting with a capital letter and a single period at the end. And do not refer back to only a portion of another claim in a further dependent claim. So, for example, you should not write the widget of the apparatus of claim 1. What you should do instead is write the apparatus of claim 1, wherein the widget is made of iron, for example. And do not replace elements of another claim within a dependent claim. Again, we want consistency so that there's clarity in the claims. So these are some of the resources that may be of assistance to you with the USPTO, some links there. There's a utility patent application guide, a link to show you what the patent process is like, a patent search guide to help you familiarize yourself with certain search strategies. And we also have, for example, law school clinics. You can look up what law schools assist what kind of clients, for example, patents or trademarks, and also what geographical areas. There's also pro bono assistance as well, pro bono programs as well. So that concludes our presentation for today. Here is a link that'll take you to the Eastern Regional Outreach Office, which will have our contact information. And yeah, well, thank you so much for your attention.
And we will say goodbye.